The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings and a happy new year to everyone. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 851, coming to you on Monday the 9th of January 2017, the first program of The Law and You for the new year. And I am delighted to be back, and I wish to thank all of you for the generous support and encouragement you have given me to continue this program, now into its 20th year. If we live to see April this year, The Law and You would have been on the air for 20 years. I'm looking forward to that milestone. Before I get into the topic of the evening, which will be reasonable notice, a few preliminary comments, beginning, of course, with condolences to all families which have suffered recent bereavements. And the year appears to have started off with a lot of loss of lives through natural causes, thankfully. And I want to let two families in particular know that they are well and truly in my thoughts. The Backus family of Casson Hill, Mother Sabina Backus, who passed away. Her daughter Anna was my legal clerk for a good many years. Condolences to you, Anna, and all the rest of the family. And in the last 2 years, I heard of the death of Mr. David Stumpy de Freitas of Upper Sion Hill. Stumpy is a person I've known for a long, long time. And I want to let the family know that I am with them in their mourning. Let me send out get well greetings, as usual, to Sister Althea Joseph, otherwise known as Nan, who has been hospitalized once again. She was out and then in during last week. All the best to you, Sister Nan, and also to our mother Tina, who I understand has had yet another amputation. First one foot and then the other. Mother Tina, we are with you in your distress. And our patriarch, His Excellency King Edmund John, is soldiering on manfully, even though his body is racked in daily pain. And all the other brothers and sisters everywhere who are under physical disabilities or discomfort, may the good Lord send His ministering angels to ease your suffering. Final preliminary comment. I was pleased to hear the announcement of the intended opening of the Argyle International Airport on Valentine's Day, 14th of February. I know this has been a project with lots of ups and downs, but eventually we are nearing the end, and regardless of where we stand politically, this is a national project. It wouldn't go away. So regardless of what our feelings were at one time or the other, now is the time to come together in solidarity and hope that this airport will be a success in time to come. All right, reasonable notice. What is reasonable notice? Well, reasonable notice is what you usually give to people you invite to a wedding. It is what the law requires you to give to persons who are in your employ and whose employment you wish to terminate. It's what the law requires you to give to persons, for example, who are renting from you, whether apartments, houses, rooms, whatever. The law says when you are closing off those agreements, you have to give reasonable notice. Unless, of course, you had entered the agreements with written documents and that those documents had termination clauses. Then if, for example, you entered into a lease for business places, a business place, or even residential property, and you sign a lease, the lease would say for how long it is lasting, and it may have a clause saying, notwithstanding it's a 5-year lease, either side can give the other side 2 months, 3 months, 4 months, 6 months notice of prior termination, and that will then become the notice period. But where no notice period is stated in a written agreement, the law requires reasonable notice. So, from what I have said, you would gather that the law expects persons in their dealings with one another to be fair and reasonable in all aspects, particularly when it comes to terminating the relationship, to ending the relationship. So that reasonableness cannot be expressed in terms of a time for all transactions. No. The time that constitutes the notice period, the law says, should be a reasonable time. That is, long enough to give the person who is most intimately impacted time to make alternative arrangements. In employment arrangements, that person would be the worker. Because if a worker is going to lose his or her job, then the worker ought to be given enough time to at least try and find another job, to try and adjust himself or herself to the circumstances of unemployment. So the law doesn't allow you to fire somebody now for now on the spot unless the behavior and conduct of the person leaves you, the employer, with no choice. So the law isn't going to tie the hands of the employer in cases where an employee misbehaves in such a manner that no reasonable person could be expected to keep such a person on the job. Therefore, if you are employing a group of workmen and one day one of them starts to curse you in the presence of the other workmen in a very disrespectful manner, then the law would say, look, you have a right to fire that person on the spot. You pay them what they have earned up to that time and let them go because they are disrespecting you in the presence of others. But you have to be sure that you yourself did not provoke the disrespect. For example, if you are the boss man on a job site and you burst dirty words on a worker in circumstances where the worker has no choice but to retaliate with similar dirty words, you may have the right to fire him, but you will have to pay him a reasonable notice period. Now, the law tries to be fair to both sides of a dispute because both parties to a dispute will have rights. The boss will have the right to expect good work from his workers, good conduct from his workers. Similarly, the workers have the right to expect they will be treated fairly by the boss, that they wouldn't be insulted or things made unnecessarily hard for them, that they wouldn't be expected to do dangerous work without suitably protective equipment and that sort of thing. Now, the rule of thumb in employment contracts is that a person ought to be given notice for the duration of the period between one pay packet and another, so that weekly paid workers would be entitled to 1 week's notice of termination. Other things being equal, I'm not saying if there's a quarrel or if there's justifiable dismissal. But if the boss wants to lay somebody off, they haven't done anything wrong, but for whatever reason, he's running out of materials, running out of money, wants to lessen his workforce, those are the rights of an employer. Nobody can tell an employer he must continue to employ 6 men if 4 would do for the time being. He has to lay off 2. The law doesn't say you can't lay off people like that unless they have a written contract. But we're not dealing with cases where you have a written document. We are dealing with cases where you have been employed word of mouth. So the rough rule of thumb, and this could vary from situation to situation. If you are a weekly paid worker, you are entitled to 1 week's notice. If you are a fortnightly paid worker, you are entitled to a fortnight's notice. A monthly paid worker is entitled to a month's notice. Well, I don't know of any 2 monthly paid person. The longest period that normally one would expect to go between getting a pay and another pay is 1 month. Now, it doesn't mean that because your pay period is 1 month, that it is only 1 month notice to which you would be entitled. No. There are many jobs, and the higher the quality of the job, the longer the period of notice required. So professionals and semi-professional persons would be entitled to more than the 1 month notice of dismissal. As to how many months, it all depends on a lot of factors. How long you've been working with the same firm or the same employer, the nature of the work you do, how long it will take you to get another job of equivalent quality. So there have been cases where professional and semi-professional people have gone to court complaining about short notice. That is, they've been laid off or dismissed and only given a month or 2 months notice. There have been cases where the court has awarded workers who have been dismissed up to 6 months notice. In other words, the court has said, if the boss wants to dismiss you instantly without a justifiable reason, then they have to pay you 6 months' salary in lieu of notice. In lieu of INLIEU, in lieu means in place of notice. So the employer hasn't got to keep you on for extra time unless the employer wants to. There's nothing to stop an employer, say at the end of January, when you are receiving your pay for January month. The employer can give you a letter saying, as of April, May, June, or whatever, your services will no longer be required. So you would come to work until the end of the time when the employer had told you you would be laid off. Then you would not be entitled to any pay in lieu of notice because you would have got the notice. It is only where you are fired without proper notice that in most cases, the employer would have to pay you for the period of time that the court would say they ought to have given you notice of termination. So if you are not given proper notice, and the length of the notice, as I've said before, would depend on the kind of work you're doing, the length of time you've been in that same job. For example, if you've been in that job with somebody for 8, 9, 10 years, 15 years, then it would not be reasonable for them, just because you're monthly paid, to give you 1 month notice. On the grounds of the length of service you have put in, a court would say, never mind the person was monthly paid. It's okay to give a month notice for somebody who has just been on the job a few months and you want to fire them. But this person has been on the job for 8, 9, 10 years. You have to give them a longer period of notice than that. And since you didn't give them, you have to pay them for a reasonable length of time that you ought to have given them notice for. Thus, there are many factors which determine how long the notice period will be. Now, I was speaking about employment, but there are other situations in which the question of reasonable notice comes up, and the most frequently occurring situation is that of the rental of premises. Now, you want an apartment to rent, you see an advertisement in one of the newspapers, you call the number, you make an arrangement, you agree to pay the $600 or $700 or $800 a month for the apartment. Now, usually, nothing is in writing, although I've told you before, you should really have these things put in writing, But let us say nothing is in writing. So you rent an apartment, you're paying $800 a month for the apartment, fine. Nothing is said about how long you're going to rent it for. You expect to be there as long as you want to, and the owner of the premises would be happy to have you there because you are a rent-paying person. You are helping him to pay his mortgage and so on. Something happens and either the owner of the premises wants you out or you want to leave. Now, just as the owner is expected to give you proper notice to leave rented accommodation, you, the tenant, have a duty to give the landlord proper notice of your intention to leave. You can't just pack up your things and go and pay your rent and tell him, oh, by the way, I'm moving out my things tomorrow, without giving the landlord any notice at all that you're going to leave, and he has the place vacant for a month or two while he makes arrangement to get somebody else to rent it. No. The law requires you, the tenant, to be as reasonable as the law requires the landlord to be reasonable. So if a landlord wants you out of the premises, you normally should get notice for the rental period. You pay rent month by month, the landlord ought to give you at least 1 month's notice. If there were other arrangements, for example, the place wasn't finished when you went in and you decide, okay, you take the responsibility for finish tiling the bathroom, for finish installing kitchen cupboards, for finish some painting and so on, you and the landlord have an arrangement where the landlord may say to you, you take the responsibility to do the finishing touches, bring the bills and show me. If they're big bills, let me prove them beforehand, and you will deduct from the rent what you have paid for these finishing touches and so on. Now, you can have that arrangement. But then, if that is the case and you have taken time and effort to do the finishing and you take it out of the rent, soon as the place is finished and looks real nice, much nicer than when you moved in, the landlord decide, he could get another $100 or $200 a month rent for this place. But you're not going to, he can't ask you for the extra rent. So he says, look, I want back the place from you. Here, get out. Go. Because he has the intention of put on another $100 or $200 to the rent, to rent somebody else. Now, clearly that is worthlessness. And the law, if you went to court, the magistrate's court, because you can't go to the high court unless the amount you're quarreling over is at least $15,000. You can go to the high court, but you will not get costs. And the objection can be taken if you took something of lesser value to the high court. The other person could object and say, look, you should have brought this case before the magistrate's court. And the judge may well say, fine, I'm sending this back to the magistrate's court. That is where this matter should be dealt with. So, you go to the magistrate's court and you say to the court, look, I rented this place from my landlord. We had an arrangement. I finished the place, took it out of the rent, and as soon as I finished, cleared off what I had spent equal to the rent, he threw me out. In that case, the magistrate may well say, look, no, you can't throw the person out. You have to give him a few more months. Now, we do have legislation which have a 6-month period. That can be invoked. But I'm just using that to show that the court has the power to demand fairness from both sides. How does the court decide what is fair and what is not fair? Well, that is why we have judges and magistrates. They are trained to make decisions of that kind. They are trained to analyze the evidence governing a situation and to decide what is fair and what is not fair. Remember, judges and magistrates handle these things day in and day out. They develop an expertise depending on the evidence and who they believe. Now, you may have a situation where it's the landlord's word against the tenant's word as to what was said and agreed. Nothing in writing. The landlord says one thing to the court, the tenant says something else. Who is the judge or magistrate to believe? Again, the judge or magistrate uses his or her experience and makes the decision as to whom they believe. Now, judges and magistrates are not perfect people, and occasionally they may believe the wrong person. That happens. They cannot guarantee perfection, but to the best of their ability, they will try to weigh the evidence and they come down on one side and the other. One thing the judge and magistrate can do, they can say, well, look, I really don't know which of you to believe, so go about your business. No, the courts have to try and make a decision, make a finding of fact on conflicting evidence. So ultimately, the question of what period of notice is reasonable ultimately comes down to two things. Decided cases, so you look back at the old cases or cases decided before, whether in St. Vincent and Grenadines or elsewhere, on similar facts and see how those cases were resolved, and you try to apply those principles to the case at hand, or just an experience of the judge or magistrate who has to make a decision. Now, throughout the law, the notion of reasonableness is one of the most pervasive notions in law. You often hear judges and magistrates talk about a reasonable person would have done so and so, or it was not reasonable for this person to have done so and so. Ultimately, reasonableness comes down to a question of experience guided by cases decided on the point. So when you go and you print your wedding invitations, You will normally print them 2, 3, 4, 5, 6 months before the wedding because you want to make sure the people you are invited are getting a reasonable period of notice. They have to make preparations. Some have to travel. So you would only invite somebody to a wedding now for now if you are getting married now for now. And of course, that is not usually the case. In the old time days, when people were more strict and, fathers would react angrily if their daughters come in pregnant, and the first thing they'll ask them is, when is he going to marry you? And the daughter will say, well, me not yet, and so on. And some old-time fathers, there's something called shotgun wedding? That is what they refer to. Literally, the father would, not in St. Vincent because, abroad, father will get a shotgun and say to the fellow, if you don't marry my daughter in such a time, you're a dead man. And the parties have to scramble and put a wedding together and so on. But these don't happen these days. These days, people plan a wedding and they make sure that the people who are being invited to the wedding have good enough time in advance. So much so that it happens to me if I don't write down a wedding invitation in my diary right away. Sometimes you misplace it among other papers. And next thing you know, somebody's meeting and say, Mr. Campbell, how come I see you at my wedding, at my daughter's wedding? You say, no. So to avoid that, I write these things down in my diary. So, reasonable notice. It's the law trying to compel people to be reasonable in their dealings with one another. What you don't like for yourself, don't give to others. And what you would like for yourself, then do that to others. Amen? So I'm giving you reasonable notice now that I'll be before you next week, Monday, DV, for another presentation in this public service nation building series, The Law and You, if it be the will of the Lord. Until then, do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.